without further ado, just want to quickly introduce Justice Mukta Gupta. Justice Gupta began her legal career in 1984 after enrolling with the Delhi Bar Council. Over the years, she handled a broad spectrum of cases spanning civil and criminal laws to constitutional and service matters. In 1993, she was appointed as an additional public prosecutor in the Delhi High Court, and in 2001 became standing counsel for the government of NCT Delhi. Known for her work in high-profile criminal cases like the Parliament attack of 2001, Jessica Lal murder case, and Nitish Katara murder case, among others. She also served as the special counsel for the CBI in major cases like the Naval War Room League case. Justice Gupta's commitment extended beyond courtrooms as she engaged with the Delhi Legal Services Authority to support the rehabilitation of destitute women, juveniles, and prisoners. Appointed as a Delhi High Court judge in 2009, she became a permanent judge in 2014, retiring last year. Known for a balance of compassion and firmness, she delivered 65 judgments on her penultimate day. Ma'am, we welcome you on behalf of ACJ and IJR. And Professor Vijay Raghavan, much loved universally by students and faculty alike, including prisoners and prison officers. Professor Raghavan is also part of the steering committee of the IJR. I think Janki has covered his current responsibilities, so I'll skip that. Professor Raghavan has trained police, prison, and judicial officers on issues like gender and human rights. He has served on various government committees and academic boards and is associated with prestigious journals. His contributions have earned him international recognition, including the influential Scholar Award at the International Human Trafficking and Social Justice Conference 2021. His primary research interests encompass access to justice, prison reforms, social work practice in criminal justice, human trafficking, rehabilitation of prison inmates, homelessness, penalization of poverty, and implementation of correctional issues. He's also a very good storyteller. So without more ado, I'll hand it over to Dr. Raghavan.
Thank you, Vijay. I especially want to thank the Asian College of Journalism for having organized this colloquium. Thank you to all of you to have been part of this. I'm very happy to be here for a very simple reason that personally in my work with prison populations, I've had a very good experience with journalists, especially in the earlier part of my career. Those kind of journalists don't really exist anymore, the way I see it. So I'd like to tell you a very short story about one such encounter. This was way back in 93, 94, that there was a journalist in Times of India called Shabnam Meenwala. And she came to me one day and said she wants to write an article on under-trial prisoners. And I was a social worker working in Prayas in those days. And so we had a chat, and based on that and some other interviews that she did, she wrote an article in the Times of India on languishing of under-trial prisoners. The Bombay High Court converted it into a suo motu PIL. And that PIL is known as Shabnam Meenwala versus State of Maharashtra case. And Mr. Colin Gonsalves appeared on behalf of Shabnam. And we were appointed as party respondent in that case. And I too was a very young social worker in those days. And I suddenly got this letter from the High Court, the Chief Justice's Court, that please appear. And it was just a 1 day's notice. So we just ended up standing before the High Court, and this Chief Justice asked me, what suggestions do you have to improve the situation? I was not even well prepared in terms of what to say, and I blabbered some things, and luckily he noted down all the points that I made, and one of which, a suggestion that we made, is that there should be a state-level interdepartmental committee on prisoners, which should meet on a regular basis and should continuously look at what are the issues and problems that are faced in prisons, because prisons is an interdepartmental subject. It doesn't only concern the prison department. There's health, there is education, there is women and child, there is vocational education, etc., etc. Because we were made a member of that committee, luckily, we have kept that forum alive since '96. And this committee meets at least once a year. It is chaired by the Principal Secretary, Law and Judiciary Department. It has members from Home, Women and Child, Health, Legal Aid, etc. And this committee has helped in at least addressing some of the issues that keep coming up, which we identify when we are working at the ground level. My point is that there is a scope for good journalism to work in close coordination with field realities, including organizations and activists. And Sukanya's work is a testament to that. And one feels very, very proud that she is a product of TISS, she's an alumna of TISS, and Justice Muralidhar has appeared in that matter. I think we should give a big hand for this. So with that short kind of introduction about why I'm happy to be here, I'll just flag a few issues that will introduce the topic for today, which Justice Gupta will speak about, which is what are the issues which plague our prison systems today. I'll start with a very small incident or a case that has happened just 2 days back. In the Arthur Road prison, there were two people. The woman was in the Baikala prison and the man was in the Arthur Road prison. 80-year-old man, blind, and his daughter, who was 65 years old, were arrested 2 years back into 2022 in a case of kidnapping and trafficking of 2 children. I'm particularly giving you this example because it looks a little complicated. The story is, as per the charge sheet, that this man and his daughter were standing outside a railway station, and there was a man who was also standing there, and he told these 2 people to just look out for his 2 children, aged 5 and 2, because he wanted to go and buy idlis, some nearby store. And when he came back, the children were missing and those 2 people were also missing. And then apparently the police was pressed into action, and finally they found these 2 people along with the 2 children in a faraway place called Kalyan in a railway station, apparently about to board a train to an outstation district. And so they were arrested in all these charges. When our social workers and lawyers spoke to them, they said that they had been framed in this matter, that they were not involved in this case at all, and that there was some other issues, particularly probably some enmity issues that this thing happened. Now, the police evidence also shows that there is CCTV camera evidence, etc. But let's not get into that. The main thing is the judge in this case, looking at all the factors, gave them a bail order of 10,000 rupees each, which means that he probably found that this case required that these people should be out. And so the bail order was passed in July, and we were able to find 2 sponsors, donors, who paid the cash amount, and just day before yesterday, the bail order was finally fructified, and today morning they would be getting out from prison, and they would be taken. They live in Aurangabad, so our team has made arrangements to help them to go back to Aurangabad. Now, why am I talking about this case? This case, in a way, highlights what are the problems in our criminal justice system. That at the time of arrest, what kind of precautions should have been taken? Is it possible for an 80-year-old blind man to kidnap 2 children along with his 65-year-old daughter? And we don't know the facts of the case. The matter will finally come up for trial, and that's when we'll know. But these people lived in prison for 2 years and finally got bail. If we are talking about our prison systems today, I'll just point out 3-4 issues which I think are very important for us to think about. I don't want to talk about the issues which everybody knows about. Under trials, 75%, overcrowding of our prisons, 130%. Let's not talk about that, it's well known. But some of the other issues that probably require our focus and attention is, I think the delivery of legal aid services is the most important link between languishing of prisoners and getting access to justice. The moment a person gets arrested, he or she moves heaven and hell to ensure that they get competent lawyers to stand for them. But for a large number of people who don't have either financial resources or legal literacy, they end up either not having a lawyer or having a lawyer of poor quality. And many times, I'm not saying this only about legal aid lawyers. Even private lawyers, a lot of them just fool the public by taking lots of money from them and then disappearing. So there is the issue of accountability of our legal aid system. No one wants to go and complain in the Bar Council because they are worried that it will create problems, etc. The other issue I want to highlight is the issue of bail. That in our country, bail continues to be property related. That is, you need to have a surety, or you need to have property, or you need to have cash, which means that it works against the poor. Whereas the concept of bail is about risk assessment. How does the judge take a decision that this is a safe person to be let out on bail? And there could be so many other ways by which bail could be given. But somehow we continue to look at only surety bail and cash bail as the two ways of, and that privileges some and disprivileges the others. The other issue I want to highlight is particularly problems faced by women prisoners. Women prisoners face 10 times the more problems than male prisoners because they are living in a patriarchal society and they get excluded from their own families and communities once they get arrested, particularly in rural areas. And for them, losing touch with their families, losing touch with their children, losing touch with their own identity. Because in most cases, these are women who come from stereotypical traditional societies, and they are a mother or a sister or a daughter or a relative to somebody, and all those roles get collapsed into one role, which is your under trial number or your convict number. And we have seen case after case of women getting mentally ill after they enter the prison premises. Then there is the issue of children left outside. This is a very serious, neglected issue in our justice system. When a person gets arrested, what is happening to their children left outside? And our work, particularly with women prisoners, has shown that children left outside suffer neglect, they suffer mental health issues, they suffer from malnutrition, they suffer from dropping out from education system. Some of them even elope or run away from the situation because they don't know how to deal with it. And finally, I want to talk about the post-release support. This is probably one area where there is hardly any work going on in our country. And somebody, Mr. Soumyanarayanan, the probation officer who was here, he mentioned about it. That what about the rehabilitation efforts? We don't even have a department in our country which looks into the issue of rehabilitation of prisoners. Or leave aside prisoners, custodial populations. We can look at children's institutions, women's institutions, and prisoners. There is no department at the central level or at the state level which is like the nodal department to look at the issue of rehabilitation. And we don't have a structure, we don't have services. The whole area has been left to some few NGOs doing whatever they think they can. There is no scheme for their rehabilitation at the central level. Some states have schemes. Maharashtra has a scheme called Grant and Aid to Release Prisoners, where a released prisoner can get up to 25,000 rupees on release. So these are some of the issues that probably we should be talking about in the public domain. I'm very, very happy to welcome Justice Gupta because she's going to be the main speaker for today. And my job is to just moderate the discussion. Thank you.
At the outset, I must thank Asia College of Journalism and India Justice Report for getting me today here for sharing my views on a very important topic which affects a large population of this country. But fairly, the topic given to me is the impact of BNSS, that is Bharati Nagarik Suraksha Sanhita, on the prisons and the prisoners, which I think I would have very little to offer, because BNSS, in short, as we call it, is primarily 95% the same as the CRPC, the old Criminal Procedure Code, and only 5% tweakings are there, some making it more of a police state, and a little bit in an incremental advantageous steps. So I like to hurry up this topic fast, giving some of the points, but as Dr. Raghavan and other speakers put forward, our focus should be on the reforms and what we can do to have a way forward to help the prisoners and the prison systems. Because I've always called it's like whatever you do, it's a drop in the ocean, and it always requires a continuous mandamus, continuous monitoring to ensure that the prison systems work with their full efficiency to the best of their ability to the prisoners, their families left behind, to the victims, and the society at large. Now, whenever we think of a prison system, some of the issues which crop up our mind are overcrowding, delay in trials, resulting in prolonged detentions, unsatisfactory living conditions, staff shortage, poor training, corruption and extortion, inadequate social integration, poor spending on healthcare, social reintegration programs, and lack of legal support and an indifferent, inhuman approach. I would say one of the biggest vices of a prison system is lack of communication with the prisoner. He gets totally obliterated from the mainstream. The family gets a meeting for a short duration where they cannot communicate properly. And if somebody is out of the family for 4 years, 5 years, 10 years, in fact, the family also learns to move on without the presence of that person, which is a big challenge when the person comes out. And when we think of prison systems, a prisoner, immediately we have a picture of a man or a woman surrounded by police officers, moving either to the jail or to the courts, where we see his liberty has already been compromised. But what if his right to live with dignity is also compromised? This is one of the major steps which has taken the BNSS backwards. Under section 43(3) BNSS, police has been given ample power and discretion to handcuff a person, keeping in view the gravity and nature of the offense. And there are certain category: habitual offenders, one who has escaped, one who has committed organized crime, terrorist act, drug-related crimes, possession of arms, rape, POXO, murder, offenses against the state, and the list is on. Way back in 1980, Supreme Court in Prem Shankar Shukla said, nature of gravity is not the criteria to incapacitate a person and iron him, to bind him to the shackles. The only criteria which can be is that he is likely to escape. But now the legislature has turned around and said, if he has committed any of these offenses, then the discretion lies with the police to put handcuffs and take him to the court, take him to the jail, take him to the police station. And they can obviously parade him. Look at the case where there may be, now, I think we must have all heard of Makoka, Maharashtra Control of Crimes Act, and then Unlawful Activities Prevention Act. The two offenses under them were Organized Crime and Terrorist Act. Under the new Bharatiya Nyaya Sanhita, these offenses have been brought as sections 112, 111, 112, and 113 respectively. 111 is organized crime and 112 is petty organized crime. Now, petty organized crime includes petty thefts, cheating, etc. So, if two cases of civil nature, an FIR gets registered and charge sheet is filed under 420 IPC, the policeman gets the power to arrest the alleged accused, parade him, take him wherever in the handcuffs. Now, this is a very drastic and retrograde step to my mind, and this is not only violative of what the Supreme Court held, it is also violative of the right of presumption of innocence of the accused till proven guilty, as also there is a dichotomy in this provision because section 46 of BNSS, which was earlier 49 CRPC, said a person arrested should be subjected to no more restraint than is necessary. So if he is voluntarily surrendering and not running away, then what is the need for handcuffs? So this is going to give more teeth, more power to the police, and also add up corruption. All he needs to say is threaten the person that I will handcuff you and extort whatever is required. The most important problem which plagues any prison system and the prisoners is delay in trials, non-grant of bail, resulting in overcrowding and prolonged detention. There are some amendments brought in the BNSS, and we'll need to see how much they impact. Section 479 BNSS, which is same as 436A CRPC earlier, warranting release of first-time offenders if they have completed 1/3 of the maximum sentence period, is now amended to bring it down from 1/2 to 1/3. And if there is a minimum prescribed, then also it has been brought down to 1/6. Supreme Court recently, in a suo motu petition in inhumane conditions in 1382 prisons, passed an order for release of all such prisoners throughout the country on 23rd of August 2024. But whatever little experience I have, you take it for an offense of, this will be applicable only till offenses which are punishable till 7 years. And where the offenses are punishable till 7 years, most of the people get out on bail after a period of 6 months, 1 year, 2 years. So even this may not have a drastic impact on the reduction of the population in the prisons. There are yet another leniency has been shown in the plea bargaining provision, which have been continued. However, it says where there's a minimum, once he has undergone 1/4 of the minimum, which was earlier 1/2, he should be released, and 1/6 if there is no minimum prescribed. Now, the problem with this amendment is the application has to be filed within 30 days of framing of charge, and it does not amount to compounding or quashing of the offense, because it is kind that you plead guilty, and on being pleading guilty, you are then released on a sentence. So it is virtually sentence bargaining in lieu of undergoing a full-fledged trial. In the new BNSS, there is a lot impact has been given on the forensics, which is a welcome step, that wherever the investigation is required for an offense of beyond 7 years, there has to be forensic team, forensic investigations done. And the second thing is digital recording of evidence. Now, provisos of sections 265, 266, and 308 BNSS provide examination of the witnesses through audio-video means at any place notified by the state government. And the move initially was to notify some place in the police station so that the evidence is recorded very comfortably. There were protests from the lawyers, certainly the Bar Council. And then on 15th July 2024, immediately the Home Secretary Union of India wrote to all the chief secretaries saying that the places to be notified should not be in the police station. Imagine the evidence which has to be before the court being recorded in a police station right in front of the police officer. What is the sanctity thereof? And whether it would be really admissible will be all the issues. So in any case, that step gets rectified. Now, confession is also permitted to be recorded through VC under section 183 BNSS. The salutary purpose of confession is that the judge has to be satisfied that it is free, voluntary, and there is no pressure. Merely because the counsel for the accused is present will not ensure that the confession is voluntary, free, and can be acted upon. So to my mind, there should be no recording of confession through VC mode because the court should meet the prisoner one-to-one and be satisfied personally, and then in the closed room record the confession. In fact, technology really helps, and I'll just give an example long back. When in Delhi we had the VC facilities, we introduced in the Delhi prisons, we created 2 rooms with VC facilities connecting them to all the courts so that the judicial remands could take place. The explanation of the prison department and the police was this will help save lot of time utilized in traveling, the staff deployed for their protection, safety, as also help in saving lot of money. But after some time, when we spoke to the prisoners, we found that they were not happy. The reason being, remand had to be after every 15 days. When they were produced in the court, they had the chance to meet their families freely and they could eat home-cooked food. Now, for a prisoner, this very little aspect of being able to meet the family physically in court was such a great attachment, and the fact that you moved out of the prison after every 2 weeks, which was jeopardized by this VC remands. So what we feel is an incremental step may not be actually the incremental step for the prisoners. There is yet another problem with this. Now, the prisoner will attend the VC from where? From a designated room in the prison complex, where obviously the officers of the prison department will be there. Now, if there is any atrocity on him or any problem which he is facing, he will not be able to tell. But once he comes to the court, he or she will come and explain what happened so that the judge can physically examine and take remedial steps. We've all seen number of times when the accused are brought, the judges themselves say, why is this injury on you? What happened? You seem to be unwell. Did you get any medical aid? Now, when you go through all these steps through the VC, probably that one-to-one interaction which is required between the prisoner, accused, and the judge will go away, and 90% of his problems will be unheard and unlooked after. So my take on this would be that it should be still in the physical present, in the open court system, when the court is able to see everything on his or her own. There is yet another amendment, or I would say a small tweaking which has been done in the erstwhile section 154 CRPC, which related to registration of FIR. So in that, section 154(1) CRPC, a small phrase has been added, which is now 173(1) BNSS, irrespective of the area where the offense is committed. The purpose was that often there would be quarrel on the jurisdiction which police station will register the FIR. But this broad phrase which has been added, the impact is, supposing an offense today is committed in Chennai over here, anybody knowing a police officer in a Thana SHO somewhere in Bihar, Uttar Pradesh can go and lodge an FIR over there. Not only he will be legally entitled to lodge the FIR, an investigation thereon can be carried and an arrest made thereon. Because section 183(1) CRPC says that the confession will be recorded by the magistrate where the FIR stands registered. Now there is amendment brought in the section 173(1) permitting registration of FIR pan-India, but simultaneously there is no amendment brought to the place where trials will take place. Earlier the provisions were sections 177 to 184 CRPC, which are now 197 to 204 BNSS. They say that the trial will take place where the cause of action arises, where the offense is committed, or where the consequences of the offense flow, like in a kidnapping, person is retained, in a case of cheating, the money is retained, all that. Now look at the dichotomy. If the FIR gets registered in some other state, for the trial, it will have to be transferred to Chennai. What will happen? Which court will decide the bail? What will happen to the last remand before filing of the charge sheet? When will the accused be transferred to custody to a prison in Chennai? And where will be the continuity of the investigation, trial and all? They just go for a toss. Some of the sentences, if there is some relaxation in the sentencing and power is given to the court, which was till now, to modulate the sentence as per a circumstance, because a theft of a simple bulb will also be a theft of a bread of loaf will be theft, and a heist for in a jeweler's showroom will also be theft. But the fact is, the courts have the power to modulate the sentence and leave it for imprisonment or fine. Now, in many of the provisions, the word which has been used is imprisonment, which may extend to 7 years, 10 years, and a fine. Now, the moment or is changed to and, the impact is that the sentence has to be mandatory and the fine is also to be mandatory. In fact, when the initial draft came up, instead of the words, draft of this BNSS and BNS came, instead of the words, which will extend to period of so and so, the words used were, which will be for a period of 7 years, for a period of 10 years. So virtually taking away the discretion from the court in the sentencing procedure, because if the word was for, the court had nothing except to award that very sentence. Fortunately, that gets remedied before it is passed. Community service has been provided as a sentence, as one of the 6 sentences under the section 4 of BNS. BNS does not define it, but section 24 of the BNSS defines, 23 of the BNSS defines the same. As a work beneficial to the community without any remuneration, a court-ordered work beneficial to the community without any remuneration. Now the problem is, community service as a sentence has been provided only for 6 offenses, that is 202, 209, 226, 303, 355 and 356 of BNS. For rest all, it is imprisonment and or fine. There is no provision that the fine can be converted to community service or the period of sentence can be converted to community service. That discretion having not been given, even if community service has been introduced as one of the sentences, it would be hardly effective. In fact, instead of rehabilitative and reformative theory, there are certain measures, certain offenses where the sentence have been made harsher. Section 374 BNSS, which was earlier 335 CRPC, provided that if a person is acquitted on the ground of unsoundness of the mind, he must be kept in safe custody. Till date, there is no mandate that all states will have short stay or long stay homes. A stay of a long term in prisons has a definite impact on the mental health of a prisoner. And as I said, if you are out of the family for 5 years, 6 years, the family learns to live without you. You are no more an important or a necessary part of that family. Besides the social stigma, what people will say if this person re-enters the family. It often happens when people who suffer from mental illness are there in the jails. They are granted bails. You call them, their family members, none come forward to take their custody even on a bond. That person cannot fill the bond because his mental condition is not so good. The family doesn't come forward to even take custody without bond, saying, no, we cannot take care of it. Now the effect of this is that the prisoner languishes in jail for years together. And I'll just give example of two cases. Long back, before becoming a judge, I was a standing counsel, criminal of the Delhi state for 10 years. So there was one Charanjit who was there in the prison for nearly 20 years. And his appeal couldn't be heard because he was suffering from schizophrenia. He would be in out of the prison to be sent to EBAS, and when the condition would impress, they would send him to EBAS. So when that petition came up, the court said, what is the remedy available? So I took those directions on my concession that direct the state to make short stay and long stay homes for such prisoners. Thinking that obviously the government must have taken steps. When I was on the bench, I was dealing with a case of Madhubala, a lady who was suffering from schizophrenia. When it came, I said, why is she staying in the jail? Despite bail being granted, you send her, if there's nobody to take her bail and take her custody, send her to the short stay home. To my horror, after 7-8 years, there was no short stay home, no process for me constructing the short stay home. Anyway, the mandamus again started, and thanks to Madhubala, Delhi now has short stay and long stay homes where such people can be kept. When I came on the criminal division bench again after 4 years, I find her appeal pending, appeal wherein her custody period is 18 years, but the prison department will not reflect the period where she was in EBAS. So they would just reflect 10 years. I said, look, this is all your custody she is in. She's nowhere out of it because no bond has been submitted. So total was calculated as 18. One of the oldest custody appeals was pending. And again, the process started. I said, call her report. Finally, I get the report that her schizophrenia is in remission. I said, this appeal has to be decided immediately. I sent that counsel that you go and meet, because appeal being a continuation of trial, it cannot be heard unless the person is in a fit state to defend himself. And I decided the appeal. It was revealed that when the incident took place, it's a very unfortunate story. She got married to a widower and who had 4 children, whose eldest daughter was just 4 years younger to this girl. Obviously, there was normal bickering in the family, which got compounded because we all know the Ashoka hotel got closed and this man got retrenched. So there was no job. All the family members started doing odd jobs. Now, scarcity of money and all these things led to bickering. One day must have been some quarrel. She had a knife. The husband thought she was hitting the daughter. He came to ward. Incidentally, the knife hit the husband who died, and there was an injury to the daughter. But daughter died much later, after 6 months, not because it could not be cured. Be that as it may, there were documents lying on the record to show that this woman was taking pills for depression much before she was married. And nobody looked into it. Keeping all those circumstances, looking into that history myself, I converted her sentence, a conviction from 302 IPC to 3041 IPC, and released her on the period undergone, directing the state to take care of her in the short stay home because nobody will take care of her. The purpose of conversion was, if it was a case of conviction under 302, she wouldn't have been released, the matter would have gone for remission to the remission authority. Now, they would have their own views thereon, whether to live or not, so her agony would have continued. But this is what happens. This is one case of Charanjit, one case of Madhubala. There are many, many, many more such cases in prisons, and years of incarceration, if they are not gainfully, properly channelized into positive direction, they'll land up into these situations. So, two very important aspects in the prisons which I find there is no thought, no advertence to them, is that how to gainfully employ people in the prisons and to create a robust legal aid system. For the namesake, we have legal aid systems all through the country. They are doing very good, but whether they are able to interact with the prisoner, most of the time the petition comes, is that stereotypical 2-page where they have not even interacted with the prisoner. Now, when you talk to the prisoner directly, he tells you so many things which you are able to find from the file, which has an impact on your decision. And to overcome this problem, while deciding appeal, I think myself, Justice Murli, we would say that these are the appeals we'll be hearing on the next day. So please tell the prisoners to join from the VC. So if the counsel is not present, if the counsel has not argued properly, or is unnecessarily taking adjournments, the prisoner gets to know it. Secondly, if there is something specifically beyond what is argued the prisoner wants to tell, he tells to the court directly. Now, this system of taking the prisoner on board through VC system turned out to be very effective in the Delhi High Court. As Mr. Raghavan said, that children are left out and there is nobody to look after them. Yes, this is a very tearing problem. And to overcome this problem in the Delhi prisons, around 15 years ago, we all started. Firstly, if the child is less than 5 years and there is nobody in the family to take care, the child will come with the mother, but he will be kept in a creche. And they were no less than the creches outside. So the child will not be in a prison atmosphere throughout the day. Yes, of course, at night he was sent to the mother to sleep, with the mother to sleep, but the creche will take his food, sitting, playing, all facilities, eating throughout the day was taken care of. Plus, if there was nobody to take care of the children, after 5 years, those children, it was a duty of the jail department to see that these children are put in proper hostels where they get education and they are properly looked out. Further, for post-release support, because all prisoners who are convicts are supposed to work and they get remuneration. Some of them, in fact, run their families from the remuneration they get. But when they are released, besides the money which they have collected, they are given money to support in rehabilitation outside. There is a specific fund for that purpose. Besides this money, it is very, very important to engage them in such vocations during their stay in the prisons, so that when they go out, obviously they've lost their old vocation, that they can look forward to a meaningful vocation and rehabilitate in the society. I think in the earlier session, one of the probationer officers said, and that was a question you put, that what about the society's response? I'm grateful for that question. In fact, one of the biggest hurdles comes in rehabilitating a prisoner, and more than a prisoner, a juvenile delinquent, because of the society. That peer pressure, the family, friends, the so-called neighbors don't let it happen. So it's very, very important to have this counseling, counselors, probation officers, which not only engage the family, but also engage the neighborhood. To make a small effort in this direction, the Delhi Juvenile Justice Committee had ventured to have such places in the society itself. So, because in juvenile delinquency, it's mostly associated with drug de-addiction. Both of them are complementary and supplementary. So on experimental basis, around 12 to 15 years ago, we opened a de-addiction center in the observation home. So all children who were into addiction were not kept in the observation home, but in that correctional place where they were given first the medical treatment, and then capacity building medically, socially, as also vocationally, to be meaningful citizens. And I am happy to say that many of them, with their trainings, once they were out of this inquiry, they were out of this rehabilitation program, they went into meaningful living thereafter. But that was not complete unless the families were associated. So families, neighborhoods would be called, and we would ensure that the officers go to the neighborhood to see that they accept the families. It is a counseling of the neighborhood, relatives, etc., which is required. And the other experiment which we did was that we gave them, we associated national skill development and gave them training in hospitality sector, to see that the children got good employments after that, when they were sent to the employment melas, not in the observation homes, but outside like a normal other candidates, and they got selected on their merits. But it was ensured that they do not do the vocation in their neighborhood. They go out some 10-15 kilometers where people don't recognize them and start their life afresh over there as meaningful citizens. I think these were some very little steps which are required for facilitating the rehabilitation of a prisoner or a juvenile. I think with this small note on the BNSS and some of the issues which were highlighted. I'll close, and any question on any of the issue would be really welcome. Thank you very much.
So, ma'am, really, really interesting, session, and particularly some of the issues that you have raised with regard to the changes in BNSS. I had one question which has actually been troubling me for many, many years. You talked about the handcuffing of, people being arrested, and now the Supreme Court judgment, in a way, has been overturned with this new provision. But there is a related issue that I want to raise, and particularly because there are two judges sitting here, distinguished judges. The way in which the police take photographs of under trials accused, parade them before the media, the way the media writes about accused persons as if they have actually committed the offense, with their full names, with their photographs. Why hasn't the courts taken this up as an issue, that this is violation of their fundamental right of, privacy and dignity, because they are not yet convicted. They are just under trials. They are accused persons. And I'm raising this issue particularly because we are in a college of journalism. The journalists are all the time rushing to get their names and their photographs published in the media. What are your views on this?
No, I'm thankful for this question. Actually, that is my grievance also. The way it is projected on the day one, we've seen it even as on today. Yes. As if the person who's been caught is the culprit, and in some newspapers or the media reports, it would even come, be hanged to death. Even if there is no provision for hanging to death for that offense committed. I remember long time ago, there was a senior officer, police officer. It was a case of 354. And the title was, he should be hanged to death. Under which provision? See, that's the problem. I think today the media needs to be more responsible. And with the advent of electronic media, probably the problem is rising. In the print media, there were checks and balances. The editor, the sub-editor, they would just check. Then after proofs were read, then it would go into the final version. But in the electronic media, in the name of breaking the news, I always say that they break the news. So please be a responsible media. Of course, the victim rights have to be taken care. But it's that person's fundamental right of dignity also. And that's why I emphasize that when you see him shackles, even before he's convicted, his right of innocence, presumption of innocence, which is a fundamental right and a rule of law, is just shattered because he is convicted unheard publicly, even before a court of law has passed even an order of charge against him. He may not be even present. So what we do is we just go overboard with the police version, and the police also projects it. Obviously, the officer gets the media glare. He is also happy with it. So somewhere down the line, I think media will have to be responsible. Number of petitions have been filed on this point, but then the issue of balancing the freedom of speech and where to control and where to exercise that control is the issue.
Ma'am, one more question and then I'll throw it open, which is you talked about community service, which has been introduced in BNSS. But I would like to also bring in the fact that we've been having the Probation of Offenders Act 1958, which has been there for since forever after independence. And Probation of Offenders Act is as good as community service. In fact, there is a provision under the PO Act that the magistrate may impose any other condition other than bond of good behavior or supervision. So there, the magistrate can even, ask for community service. For those of you who may not be knowing, and particularly those from law students, we have a law in our country called the Probation of Offenders Act 1958, under which a person can be released back into the community instead of being sent to prison. But, I mean, what are the chances of this community service being implemented when the PO Act itself has not been properly implemented?
See, even under the Probation of Offenders Act, this community service was very underutilized. In fact, I would say the Probation of Offenders Act was also very unutilized. Hardly out of 1,000 trials you would find in one case would person left on Probation of Offenders Act, despite applications being filed and all that. One of the reasons was that by the time the trial took place, the person would have already been in custody for 3, 4 months, 6 months, 1 year. And the judge finds it a futility to now leave him on Probation of Offenders Act. You know, as a former judge, I can say, when you are deciding an appeal and the person has gone substantial sentence of 10 years and you acquit him, there is so much of burden on your soul that what has the society, what has the system done to this person that he has been incarcerated unnecessarily for that 10 years when he was bound to be acquitted. It is not an easy job. So somewhere down the feeling, and I think that is one reason, they say he's already undergone 3 months, 6 months, so let it be released on the period undergone. That is one reason. And secondly, we have probation officers, but I think the infrastructure, facilities for the probation officers is hardly there. They have no funds to go and meet each of them, meet their families, meet their support systems, their environment. And unless you have that infrastructure, leaving a person on probation is meaningless. These are the two reasons that what I feel is it is unutilized.
Thank you, ma'am.
Thank you, ma'am, for that very valuable information that you've put out there. Like, a lot of people do not understand the differences between the new BNSS law and the law that we had earlier. You spoke about the deterioration of mental health specifically that happens in prison systems and the acceptance of prisoners by the family, how it is not very welcoming, and how handcuffs are actually something that violate the basic fundamental right that a prisoner has. Don't you think the fact that they are allowed to handcuff somebody who has not been, convicted, that point is the starting point for mental deterioration? As sir mentioned very nicely about how media goes on to take pictures and publish names. I think that very point is the starting point for mental deterioration.
Undoubtedly, that's a starting point. So a person there is only an allegation at the stage when only an FIR is registered. You've not done complete investigation. You don't know whether what the complainant is saying is truth or not. Most often they don't even find the truthfulness of the complainant's complaint. And the moment the complaint is registered, they go off and arrest and then start investigating. So the deterioration, mental deterioration starts from that very point. And imagine the harassment, engaging a counsel, the family goes into disarray, be it a person on the street, be it a common man, or be it even an influential person. It is happening across. So it affects them mentally. Only thing is, a person is of means and influential, he gets a good team of lawyers. A common man is not able to afford it. So this is the problem, that mental health deterioration, physical health deterioration starts from the day one. So I think it must be reported, and this handcuffing is, because of the nature and gravity, cannot be the criteria. cannot be
I
the
have
crime.
another question if that's not a problem.
No problem.
You mentioned about how VC plays out negatively for the poor in the country, and how there are other several instances where you mentioned how the law acts against or doesn't favor the poor. But like looking at how you mentioned all of them, I mean looking at the law right now, don't you think the BNSS law is something that actually doesn't provide justice to the poor or works in, terms against them consistently and in majority? Like even in case when, say, they are handcuffed, a person with, a good PR team and sort of a lot of wealth can manage to overcome that particular instance and move on with it. But somebody who's again poor, that person might not be accepted by the society and that person might not be taken care of at all. So it just seems like the entire law works against the poor instead of, sort of providing some relief.
See, the purpose which is stated to be for BNSS and BNS and BSA is to overall the colonial laws which we have. But BSA is verbatim the same, except for some tweaking in the certificate for certificate and forensic certificate of admissibility of forensic digital evidence. BNSS is also same and BNS is also same, besides addition of some new offenses and deletion of some. So there is no overhauling, and the 5% tweaking which has been done, I would say it is more of retrograde than a progressive measure. And you've rightly said, and even I said that. So the person is arrested, the police has the power because of the provision. He will immediately say, I'm going to handcuff you. The person will, it's a kind of extortion. The person will just immediately cuff off the money or whatever he wants. A richer person will get away, but a poor person will face this. That's a problem. So it doesn't do away with the colonial mindset. This is not a progressive legislation, to my mind. And there were so many other amendments required which have not been brought into it.
Thank you. In fact, on the issue of overcrowding, I mean, handcuffing, even before this BNSS was there, if you just go to the beggars court or you go to the railway offences court, people are just lined up with tied hands with one rope, and he's right in front of the magistrate. And the magistrate is watching it and giving a remand. So, I mean, Supreme Court judgments are very important, but, at the ground level, things are often not the same. There was somebody there. Yes. Murli, you want to speak?
Yeah.
Okay. Can I just come back to you? Yeah.
Just I want to stick to this impact of BNSS on prisons. See, in the CRPC, the police commissioners are given executive magistrate powers, under which preventive detention laws are operationalized, and Tamil Nadu is one of the states which is extensively using preventive detention under that. And this power is also conferred on the district magistrates. But BNSS is also conferring that power to the superintendent of police, which exists in Uttar Pradesh since 1982, which is being now made pan-Indian. I think it will have, Telangana has seen it as a serious problem. Now, Gujarat and Tamil Nadu are the states which are without trial, people being sent to prison. This is going to be a serious problem in future. That's one question. The other one is, BNSS says, it seems that it removes the discretion for imposing concurrence of the sentences. When a prisoner offender is sentenced 2 sentences for more than one offense. I think judge's discretion is removed under the new law. That is also going to hugely impact the prison population. The third important, very impactful change seems to be under CRPC, the criteria for declaring somebody as a proclaimed offender is very specific offense. Now they made it into
10 years plus.
10 years plus. All the offenses which attract more than 10 years of offense. This is very, very important because this is the criteria for trial in absentia, which seem to be almost making, at least in theory, a real trial in the court unnecessary. Or in absentia it can be done. I don't know how it is going to pan out, these three provisions in future.
No, you are absolutely right. 107-110, which was earlier there, has been brought as it is, and the executive magistrate. If you see any police station, by the evening you have 5, 6, 7, 10 people whom they haul up for creating, disturbing the peace and tranquility of the place. And then they are put up before the magistrate, their own executive magistrate, which is the ACP. And then he says, okay, I release on the bail bond. That bail bond verification takes 2-3 days. So it's good enough to keep that person in custody for 3-4 days. Now, that provision has been carried on in BNSS verbatim the same. As far as concurrent sentences, it is said, considering the gravity and nature of the offenses, the court can pass concurrent sentences, with the result that you may not pass concurrent, so that it can be consecutively. So if there are 4 offenses committed together, so first 3 years of one, then 5 years of another. And earlier it was that cumulatively they will not be more than 14 years. Now it has been modified to 20 years. So cumulatively, if the judge says that the offense sentences will run consecutively, they can run consecutively till 20 years instead of 14 years. And the third thing which you said also is absolutely right. Proclaimed offender, earlier there were only 302 and some state offenses against the tranquility which were there. Today, any offense which is punishable with 10 years plus, a person can be declared a proclaimed offender. And not only that, the trial can be held once he is declared a proclaimed offender and the judge returns a finding that he is avoiding the trial. The trial can be held in absentia, and when an appeal is filed, the appeal will not be heard against that conviction unless he surrenders. Now, juxtapose this with an FIR which for an alleged offense which takes place in Chennai. FIR gets registered in Bihar. The police officer never comes to you, but in his record shows that I've pasted, I've done everything, and you are avoiding service. Non-bailable warrants cannot be executed. You will be declared a PO, you will be convicted, much to your, without any knowledge, and one fine day you find you are a convicted person. And the appeal will not be heard till you surrender. So that's the consequence of it.
Somebody at the back, yes.
Thank you, ma'am, and thank you, sir, for your session. I wanted to ask about an inquiry into the police brutality that occurs in prisons, as custodial deaths as well as encounter killings and extrajudicial killings are in the rise in the country. Is the BNS acknowledging this issue, and is there any kind of investigation, is there a scope for investigation?
BNSS does not acknowledge it as an offense. It's the same offense of murder and all. The offenses BNS which had were the same. It does not qualify them that since it's an encounter killing. Because the police will never say it, they will say, because he was running away, so and firing at us, so in retaliation and to protect ourselves, we've done this. And it's a matter of trial. Ultimately, the court has to find out where lies the truth.
There's somebody behind you. Yes.
Can I ask one more?
Okay.
Regarding the community service, how is it ensured that this will be like a dignified form of punishment, and how can we ensure that there won't be any kind of caste or any kind of discrimination as it's outside the prison system?
See, let me tell you, many of the courts were, while quashing of FIR, awarding community service. But personally, I never did it for the reason, can you ask person from one faith to go to another place of worship and do kar seva or something of that sort? Now, secondly, there have been orders, you plant the tree. Who am I as a judge to direct planting of tree on a property belonging to a third party? Maybe the third party, even if it is a state, it is required to be utilized for some purpose. So some judges pass the order that you go and take care of the traffic. Now, if a person is a novice, doesn't know how to deal with it, the same may result in number of accidents rather than managing the traffic well. So one has to be very, very careful. I remember long back, one of the judges said, you've been a teacher, you've done this, you go and teach in the house. Now an offender, especially of a nature of a molestation, all, which family would like him to come to your place or any other place to be teaching? So it has been provided community service. We are, as judges, adverting to it, but that was in quashing matters. I think some set performers will have to be over the years, SOPs will have to be laid down. What kind of community services can be asked to be done? Because at times it may cause more harm than benefit.
Actually, on this issue in the West, community service is organized in a very professional way. There are organizations which are recognized as community service organizations. There are community service officers appointed to supervise the community service. And it is not done in the ad hoc manner in which ma'am is alluding to. So unless we have the structure in place, just introducing a section in the law is not going to really help. The person at the back, yeah.
There's one, I think the mic is here.
Okay. Yeah. Sorry.
Hello. I'm Saket Seth from ECJ, Business and Financial Journalism. We have witnessed the prevalence of encounter justice by some of the state governments in recent years, even before the accused is taken to the court. What steps is the legal fraternity or the legal system of the country taking to ensure that the states do not resort to such measures?
Very good question. But what is the locus of a legal fraternity except filing a PIL? See, apparently you may be finding that it's an extrajudicial murder, and for everybody it was so apparent. We are all not naming it, it was so apparent. Yeah. But Supreme Court appointed a committee and they didn't find any illegality therein. What else can you do? As a legal community, there was a PIL file, and a former judge of the Supreme Court was appointed the chairperson of that committee. But they took statements, and maybe not many people even came forward to give statements. These kind of issues are not even easy to investigate. Not many people come forward to make the statement as to what actually happened. Apparently there may be videos, etc., but you can't rule out tampering in the videos of what has been shown in the media, with all respects to everybody. They can be selective also. So, as a legal person, you cannot go and file a complaint before the magistrate because you don't know the complete facts. It's a matter which requires investigation. And there has to be a proper information, then a proper investigation into it. And investigation is being conducted thereon. Inquiry has been conducted, and that's all what the law ordains that it can be done.
Okay, the person in the back, and then Balay.
Yeah, hello, I'm Durga. So given the prisons are meant to be a form of punishments for who, committed crimes, some might argue that improving prison conditions contradicts the idea of, the justice. How would you respond to the view that prisoners having committed offenses do not necessarily deserve, better living conditions? And how do better living conditions align with the goals of rehabilitation and public safety?
See, nobody would say that the prisoners don't deserve better living conditions. Prisoners deserve a normal human, proper living conditions, which is a basic requirement of everybody. Of course, the prisons can't provide a 5-star treatment to everybody and should not also be provided. But the basic human needs and all facilities must be there. And that is why I think each court system has a team of judicial officers who keep monitoring. They have to go regularly visit the prisons, and there are complaint boxes kept, and those complaint boxes are opened only by those judicial officers, the district and session judges, and then as and when there are complaints, if there are, remedial actions are taken. Many of us would regularly go and visit the prisons, eat the food which the prisoners would be getting. So you have to permit NGOs, third parties getting into the system. So there is some transparency. Once those transparency are there, I think the conditions overall generally are good, but aberrations anywhere cannot be ruled out. On the flip side, I'll just like to give one example. Long ago, I got to know from the DG prisons that a lot of women who are in the advanced stage of pregnancy get admitted, commit a small crime, and then don't furnish the bail bond and get admitted in the prison. That's in the last trimester, they just get themselves admitted in the prisons. Now, one gets shocked, why should they go there? The medical facilities they would get all vitamins, all supplements, everything, proper delivery in a proper hospital. Obviously, it's a hospital delivery, not in the prison precincts. So the child is delivered at that place, and thereafter they furnish the bail bond and come out of it. Now see, what it speaks of, a sorry state of affairs. It's the same state which is spending on that woman at that stage. But it could not provide that facilities outside, but did provide those facilities when she was inside. So, basic requirement and all the facilities, good living conditions should be there. But I have always said it can't be 5-star treatments that you give in the prisons, because you are not luring them to come over there.
Thank you. I'd actually question this, thing that exists amongst many prison officers. They often tell this, that like in Maharashtra and Bombay, they say, monsoon ke dauran prisoners ka number बढ़ जाता है, छोटे-छोटे crime करके वो अंदर आ जाते हैं. I don't think anybody will compromise their freedom to come inside prison. I mean, there could be, this matter needs more investigation, according to me. Probably a proper study should be done.
Yeah, I think it should be done, but I'm telling you what they said.
Yeah.
And this could also be one of the reasons.
Maybe, yeah.
Getting good facilities if there is nobody to take care. Monsoon season, now especially people who are on the roads, they don't have any place to go on. So this is how. But that speaks ill of our otherwise state system, that we are not, if it's a state which is spending the money in the jail, why not outside there?
Ma'am, you talked about the grotesque agony, and in this colloquium also we have discovered the horrible interventions these people have to go through, and then they're acquitted after like 10 years or 20 years, and it's such a bearing on your soul also. So you also mentioned that some of the individual cases where few judges who had a conscience like yours, they made some intervention. But on a larger level, this system which is making thousands of people go through this agony, who are the characters, actors who will change the system? Where will the change come from? Is it like, or is it just limited to judges like you who on an individual case basis they change this, or is it the law ministers, the judges, the law forums, or as a whole who are planning to change
I
this?
think the responsibility lies to everyone. It lies to the society. If something is wrong happening in your presence, why is it that everybody keeps quiet? Why don't public persons come out to speak? Then it lies with the officials of the state government. It lies with the police officers. It lies with the lawyers. And of course, it lies with the judges. Because ultimate responsibility comes on the judges, so they become accountable and they keep their eyes and ears open. But the responsibility lies with each and every person in the system. The problem which is arising today is most of us ignore when some wrong is happening. And actually that is propagating of more of wrong. Why should we keep quiet at that stage?
So, ma'am,
it happens around us, it happens in our houses. We are all quiet at that time. But when it happens outside, we are all giving our comments. So the responsibility is with everybody, to my mind.
We'll
Just
have,
one
to, we'll have to
follow-up.
keep it short.
Yeah, it's very short. So is it just a problem of the people in the system or the system?
And the system comprises of the people only. System is nothing, but it is comprising of people. So it's basically of the people.
Yeah.
Hi, ma'am. Hi, sir. Thank you so much for your valuable insights on prison systems, ma'am. It is very enriching, actually. Ma'am, you said that we don't give 5-star treatments to prisoners, right, ma'am? But
No, I said I would not like it to be given to 5-star treatment because it should not be a lure to them to come to the prisons.
But I feel that we do give this treatment to certain few individuals. Like if they belong to some high social status, we do give this treatment to such people, ma'am. And this in a way creates inequality in the way we treat prisoners, right, ma'am? So what can we do to ensure that this inequality does not happen, ma'am?
See, when you say that some of them get 5-star treatment, I don't rule out. I said aberrations may be there, but sometimes those high-ups also get a very rough treatment inside. The problem of a prison system is it is too opaque. So what is happening inside, you don't get to know. You just get to know a story spinned by somebody. Now, how much is the truth in that story? None of us know. I remember long back, there was a big wig and the allegation was that they were given preferential treatment. I was told by the court, just go and visit him, find it out. When I went inside and it was all of a sudden with unannounced, he was in a normal cell with 2 other inmates. So it was not a dormitory, but there are certain cells which has 3 persons. Now the doctor had prescribed him a bed because of his ailments. That was given. And I didn't find anything special over there. So we say, that's a problem. The first question he said, when media speaks, it speaks with conviction. But how many of us find out the truth behind it? None of us have gone there. None of us have seen. None of us are eyewitnesses. So if there is, even to those people, no 5-star treatment should be given. Everyone should get medical treatment, proper medical treatment, and the best medical treatment they deserve. They need, their ailments need. But, and all basic human, proper facilities should be there. But I will still stand by no 5-star facility.
Actually, it's not so much of a question, ma'am. One is that on a slightly lighter note, what Professor Murali Kandam said, the impact and the topic is that the Supreme Court has already said, start preparing for the next 50 years, increase prison infrastructure. So there will be more prisoners for longer duration, and in a way, Supreme Court has already planned for it by instructing states to plan for, so which is a sad reflection. The other sentiment I'm echoing by friends behind me and even further is that there is no trust in the system that it will be able to punish the guilty. Firstly, it will be able to hold them guilty through a fair process, and therefore, we are at a stage where encounter killings are justified and not at all questioned. Therefore, this friend, when he asks, what can we do? And you say, file a PIL, and that's the end of the story. So I think just to sort of look forward, is there any hope that you see to make the system accountable as a whole, not prison or judge or police? Because at the end of the day, there is no trust largely. And that's why we say process the punishment, let them languish for 7 months or 8 months.
See, I would just suggest like in the CRPC and now in BNSS, there is a provision which warrants a judicial inquiry when a person dies in the prisons. Not an investigation, but a judicial inquiry. Whenever there is such incident of encounter killing, what happens, it's an SDM inquiry which is done or an investigation done. If there is some amendment of the kind that there is some judicial inquiry at that stage, maybe that may help. But then judicial inquiry itself has its own inhibitions because a judicial officer takes the statements, but he or she does not have a mechanism of investigation. How does he investigate? He or she will not go door to door, will just issue a notice, anybody who is aware of the matter, come forward and give the statements. Now, this happened even in the inquiry ordered by the Supreme Court. But how many people come forward? Whatever solution, it has to be within the framework of law. We can't have an extrajudicial system that because they have done this, we also feel they have done it, so there should be counter killings. That is not the answer to it. So we must either have a robust system out of it, where there is some amendments required in the BNSS. Otherwise, I personally don't see that anything as a general rule can be done. It has to be on case-to-case basis.
Ma'am, I want to talk about the short stay homes and long stay homes we are mentioning. So you said that it took a long time to establish short stay homes. So what my question is, I don't know if it is related to BNSS, but is there anything legally or the courts can do to ensure that the conditions in these short stay homes, like you said, there is a right to ensure health care. So how can we ensure that the proper standards are maintained in these?
See, I think there is a mental health committee in all the states. And the onus lies on that committee to look into all these aspects. This is a part of their duty to be visiting all these short stay homes and finding out how the inmates are dealt with. If it is not there, of course, the courts are there to direct that you have short stay home, you have the mental health committees, and do it. Wherever you find that there is no mental health committee or short stay home, then the PIL is the answer to that. And we have Justice Murali to steer that all ahead.